Now I'm a 50% heir. My life is completely a mess. It was not obtained according to the proper procedure.
So Mr. Magnus went in, said what he said with his magic words and just ruled the judge.
She was giving deference to Attorney Magnus and my sister's attorney.
You are not going.
Farmer John here and his family are feuding over the estate his parents left. He's spewing forth to anybody who'll listen entitlement followed by ridiculous expectations. When that doesn't work, as tends to be the case, Farmer John switches to throwing shade at his family, opposing counsel, and even the probate court judge in Oakland County. When Judge Simpson calls him out on that, Farmer John damn near triggers whiplash by flipping the victim card. Later in the hearing, he's going to lob a shot at Judge Simpson. Watch for it, and watch him flee the bench to avoid a scene.
You know what?
Let's roll, nerds.
Court calls the estate of Earl Samuels versus Jonathan Samuel. Your name, sir?
Samuel.
All right. This is in effect, and just so that we're clear on the record, it would be effectively a hearing to determine whether or not a order of eviction should be entered, but that had been entered. So I'm hearing your objections and whether or not I should let that stand, sir.
Yes, Your Honor. Because it was not obtained according to proper procedure in multiple ways. If it is appropriate for Attorney Magnus as the acting for the personal representative, if it is appropriate for him to use the landlord to obtain a order of eviction, he didn't follow the requirements of the law the way, because he just tried to continue a case from nearly 2 years ago that wasn't at all the same legal entity, even though they inappropriately called it the state of Earl Samuels 2 years ago. Was actually, Dad was alive. Now Dad died and there actually is an estate. So to come to the court as Attorney Magnus did last month and say that he's now the representative of the entity that obtained the order, the judgment or the court, conclusion 2 years ago. No,
but sir, you need to understand that there are numerous occasions where there's a judgment entered by a person being or a live person who subsequently passes away. That case is then basically renamed with their estate. And it happens from both sides, particularly in with landlord tenant. It can happen from the plaintiff side, it can happen from the defense side. So I don't know that that's necessarily an issue.
well, it is, because now I'm a 50% heir. So I have a totally different legal standing than I did initially. So, and under the law, I have.
Yes, but that your standing vis-a-vis that property would have been taken care of by the probate court.
Well, that's part of my argument is the probate court should be handling this.
No, they don't. They don't have to. As to the possession of premises, there is actually, in one reading, there's either I have jurisdiction over it or there's concurrent jurisdiction between the probate court and this court. So either of the courts can act.
I thought it was pretty narrow, the landlord tenant law saying that the ER in a case like this can only act to evict after property says, conveyed, says, it's, 705, 605,407 where it's narrow in what it allows the district court to do, because
The district court can act where a personal representative is properly before the court, but the authority for the personal representative to act has to come from the probate court. I can't confer their authority to act.
well, the bottom line is that Attorney Marcus was obligated to do things in a more deliberate way rather than just try to use something from nearly 2 years ago. And you're saying that sometimes a ruling for before that can be continued on, but I would argue that because I'm a 50% heir, that
But you would have had to have gone to the probate court, right? Because the very fact that you're an heir to the property doesn't matter. What matters is that because there's going to be somebody that's going to be able to act regarding that property. And that's going to be the estate. And whoever is the personal representative of the estate is going to make those decisions, despite your status as heir. If you have an objection to what they're doing, then you go to the probate court, you make your objections to the probate court to what they're doing.
and I am, and I'm in the middle of that, and there's appellate cases that relate to this. So there's many things going on that Attorney Magnus tried to go around that to involve this court by saying that he was continuing something from 2 years ago, which is significantly more complicated than he.
Did you seek a stay at the probate court to this court's action?
I filed a couple motions for reconsideration. I'm filing.
And the motions for reconsideration is because the probate court has ruled against you.
Right, because Attorney Magnus said things at the hearing that were not true, and the judge didn't have an opportunity to hear.
Which judge was this?
The new Oakland County probate court judge, Tracy Richards, who placed.
So Mr. Magnus went in, said what he said with his magic words, and just fooled the judge.
Well, she was giving deference to Attorney Magnus and my sister's attorney.
You are not going to, one thing that you're not going to do. I don't know, Judge Richards, I don't know. But I will say this, if you are, courts give deference to parties when they come in, all right? If you are going to indicate that a colleague of mine on the bench, despite being in another county, has shown some bias to your detriment, if you're going to make that argument here, the only thing I'm going to tell you is you better bring it. Because if you're going to make that accusation, you better bring it.
The judge was proceeding as though Attorney Magnus and the attorney for my sister would be obligated to tell the truth. And she assumed that when she asked them direct questions that they wouldn't say things, but there's material facts that contradict. So that's all parts of my motions for reconsideration, because there are.
Has she ruled on your motion for reconsideration? Has she ruled on your motion for reconsideration? Okay, so you want this court to, so why didn't your motion for reconsideration include a stay of these proceedings?
It referred to these proceedings.
That's fine. Why didn't it include the request for a stay of these proceedings and or a request to prevent the personal representative from doing specific things until such time as the judge could consider?
I asked for multiple things in the motion for reconsideration. I don't think I used the specific language to ask for a stay of this proceeding, but I'm actually, it's 2 weeks today from the hearing.
So, sir, let me explain something to you, because built in, when I was a bit shocked when the parties appeared the last time by a number of things. One of the things that I was a bit shocked about was that you did not reside in the premises. And let me tell you why that's important. Because once the court determined what it determined here, that there had been a hiccup in trying to figure that out, the great fear for the court is that somebody was displaced from the premises to their house, and that something that happened shouldn't have happened. That harm isn't really in existence here at this time. You couldn't have resided at the premises because our order of evictions have a procedure in place that allows you to get before this court prior to the execution of any writ or order of eviction. And that is basically a 72-hour hold after the posting. That's the first thing. The second thing is that, from my understanding, there haven't been any things removed from the premises.
Well, but there was harm. They removed 2 vehicles which had value, and I really need the money from those vehicles. So.
Okay, so if you believe.
It's part of the eviction.
So, okay, so if you believe that the eviction was improper, that you've lost some property, then you would have to go after the estate. That doesn't come here.
What I was asking for is just to stay the eviction until we resolve things in the probate court. So.
I don't know why I do that.
Because Attorney Magnus didn't follow the procedure in several ways.
I'm giving you your hearing now. And that is precisely my point. Other than these vehicles that you say have left, and I don't know anything about the vehicles, there hasn't been the harm that would normally inure to somebody who has been evicted in this instance, because property hasn't been removed. So I'm able then to give you the hearing as to whether or not to allow the eviction to stand. And in fact, give you, as I indicated at the last hearing, frankly, more time than you would have gotten otherwise to make whatever argument you needed to make to the court.
The argument is that the probate court should control things, and if not, then.
Then if you believe that, sir, and that this court wouldn't have jurisdiction over a property that is venued in the 14A district, if you believe that, then that argument needs to be made to the probate court to stay the eviction or to prevent the personal representative from acting on it.
I'm in the middle of that process. I've been.
So if you're in the middle of that process, then I should allow this to stand. And then you argue that before the probate court.
That I think there's reasons to not allow this to stand because Attorney Marcus didn't go through the proper steps to.
I know Attorney Magnus is just a very bad individual. I get that, but that's not a basis on which I made my decision.
Well, he
I say that.
he's, as personal representative, he's obligated to be impartial, and he's doing things that favor my sister. And
He does, I would imagine that he's doing things consistent with his fiduciary obligation to his client, that being the estate. Which there are going to be those which are involved in the estate, because it always happens, that aren't going to like that. So the real issue is you don't like what he's done.
well, from my first conversation with him, I told him that the essential thing was that the farm stay in the family, and he said that he agreed with a basic argument that the person who was trying to buy it 6 months ago didn't have a good case to be able to continue trying to buy it. But then he changed his mind. So, and this eviction then helps him proceed with the sale that he changed his mind about he changed his mind in July. In June, he told me that the person trying to buy the farm from 6 months ago.
Who's the personal representative of the estate?
Timothy Flynn, the person that Attorney Marcus represents.
Yeah. So why do you have so much animus toward this man?
Why does he have such animus towards me? I was living at my parents'
All right.
place more than
Well,
half the
apparently I struck it there. Are you listening to what you're telling me?
You're right. If someone
Are you
changed the law,
listening what you're telling me? Every sentence has begun with his name. He's an attorney representing a personal representative of an estate.
yes, and he's obligated to be impartial, and
He's obligated to do his job for his client.
and
That's his obligation.
that would potentially include me. I was the one who worked to create much of the wealth that still remains in the estate. It was my sacrifice for many years. So for him, he's doing things which will diminish the wealth of the estate.
And why would he do?
Because it's quicker. He's doing things that will resolve the estate more quickly, which is what my sister's attorney wants, rather than to achieve. I mean, for example, my parents' house is not in great condition on the outside, and I have things prepared to do work to achieve closer to full market value. But Attorney Magnus doesn't want to do any repairs and just wants to prepare it for sale as quickly as possible. So he's going to sell it to not a typical buyer, a flipper person who will.
Is he doing that against what the wishes of the personal representative are?
No, he's doing it because that's what the person representative wants, but it's against. what
Exactly.
says. What the-
Exactly. That's his client.
I also have an interest in the estate, and
You do. And if the decision is made that the property is sold, I'm presuming you'll get your fair share.
yeah, but my fair share of a diminished sale significantly. Imagine the difference between. the
Then
house.
you have to argue that to the probate court.
Because I'm in the middle of doing many things to the probate court. And
Okay.
you're saying, so a key thing, Attorney Magnus on June 30th changed the locks and.
There we go.
Staying more than
He went out there himself and did it?
what?
Nothing.
He
Go.
did it. What?
Nothing. Go ahead.
What?
Go.
Clarify briefly.
Yeah, no, you've been very good at being quiet, so we'll let that continue a little longer. Go ahead.
So on June 30th, without any notice, without telling me that I shouldn't be staying at my parents' house more than half the time, he came and changed the locks. All my things were there. He saw that my food, my computers, my clothes, everything was there, my legal papers. Imagine if someone just came to a residence where a person's living and locked them out, and then
But you weren't living there.
I absolutely was living at my parents' house more than half the time, and I had Google Maps timeline showing in 100 and.
It's a different house.
So we're talking about Attorney Marcus's actions, which are
Oh.
partial, which I keep referring to him because he has demonstrated, and the way he said at first that he understood how important keeping the farm in the family was to me, and how the legal argument to sell it seemed reasonable. But then he changed his mind without justification, and all of this is the whim of Timothy Miller and Steve Marcus, rather than what's really left for the value of the estate and respecting what my dad wanted. And people refer to the estate as being intestate. There is a will. The same people who refer to no will.
Can I just say this? All of that, you've got to take me for the probate court. I told you at the first hearing, if I wanted to be a probate judge, I would have been. I'm not dealing with the will,
But
if there is one.
you're going along with what he did.
Okay, yeah. I'm going to tell you what, I don't think I've ever met Attorney Magnus before. I don't think I've ever laid eyes on him before that last hearing. What I saw his appearance, I had no idea who he was. So don't come before this court, because I know where this is headed because of the way that you make your argument, and claim that I, for whatever reason, have some bias or some other interest in what he says to me. He has said nothing in this hearing, and I see huge problems with your argument regarding this writ.
What about problems with the way he obtained the order from you? Because
Which I'm going through the process right now of correcting.
I would argue that the way the law is, the order isn't appropriate yet, but the 605.7 is narrow in what it allows the district court to do as far as evictions. And I think I've cited it correctly.
When you say it's narrow, what do you mean?
Well, that's what I want to refer to is the 605.407 has just one reference to an estate and a personal representative. And it says after, it says after sale and conveyance. Oh, I have it wrong. 5417. So here, it 5714. I had the number one, 605.714. 1H, when a person continues in possession of premises sold and conveyed, personal representative under license from the probate court or under authority in the will. So that's when the law that let you sign the eviction order would apply.
No, sir. You need to read the other parts of the statute. That is one instance.
Well, that's the only one that I saw referring to an estate like this.
Okay.
And there is other case law. In fact, there's a case that Timothy Flynn was involved with, the state of Anderson, where they let eviction issues be handled by the probate court.
Sir, what did I say to you earlier?
I mean, you've said the probate court, but I'm just asking for you to let the probate court make the decisions until it's clearly justified under 600-5714-1H for you to.
And what I'm telling you is that I'm likely to rule. And then if you believe that I am in error, you can appeal me. Or you can seek a stay of any ruling that I may enter that you deem disadvantageous to you. You can seek a stay from the Oakland County Probate Court.
Yes, Your Honor. But you could also just have a stay to wait for some additional proceedings in the Oakland County Probate Court that.
I could do it that way. I could do it that way, but I'm telling you, I'm unlikely to do that.
I'm inviting all this to try to respect what Dad wanted, and if I was never to leave the family, absolutely. This is all I have plenty of equity in other property to buy the farm. But until Marcus locked me out of the place where I was living, we made life very difficult for the last 9 weeks. So I haven't been able to function very well. I mean, today I rode my bike here 30 miles because I don't currently have a working vehicle, because my life is completely a mess. And Attorney Magdis, by locking me out without notice of the place where I was living on June 30th of this year, did something that most would regard as unlawful. So you're not allowed to just lock someone out of a place that they're legitimately living. Attorney Magdis tries to argue that.
You know what? You coming before me, and you've just tried to besmirch this man, and you were about to, if I hadn't cautioned you, take a shot at a colleague of mine on the bench in Oakland County. Why don't you just give me the merits of what it is instead of explaining to me all the bad things everybody in the world seems to be doing to you?
I have the means and assets to accomplish what Dad wanted, and
Can I ask a question? If that's all true, why aren't you making an offer on the property?
I did, and they don't want to accept it because I have to sell my properties first. So, people buy properties all the time where they have to sell their own residence first. So rather than work with me, that's why I'm so upset about everything, because people are not looking at the facts of the things, the equity that I have. It's just a matter, I could sell things as is today and get $280,000 from my West Bloomfield previous residence, or I could do a few things and get $350,000. Or I could do a lot of things and get $450,000. Next door house sold for $450,000 earlier this year. So people can put on me under how much pressure they want. Do they need me to do something today and sell the West Bloomfield house as is for $280,000, or do they want me to get $350,000 for it so that I'll have more to buy to put towards my offer on the farm? And I have other properties with significant equity also, and it's a similar story. So the personal representative, the estate doesn't have to be closed right away. I've made an offer that's higher than the offer that they want to accept. So it's just what my parents wanted, what I've always said was so essential. So why won't the personal representative or his lawyer work with me? Why did they change their mind? Why is it okay that he locked me out of the Farmington Hills house?
Okay, that's in Farmington Hills.
Yes, and I'm
Welcome to Washington. I don't have anything to do with Farmington Hills.
right. But the one thing that you could do is to not allow this eviction to stand and just to wait for some additional probate court action. Because that's really what controls things, as you've said.
Oh, I don't think I said that entirely.
I'm sorry.
Okay, have you finished with your argument?
There are other cases where probate court was the one that made decisions about landlord tenant issues where it's not really falling under the landlord tenant law. Because of my interest in the property, the way as 50% advisee, title will ultimately, if it goes to me, will ultimately be backdated to the day of dad's death. It's like title transfers at the time of death subject to administration. So it's not a typical landlord tenant case, and there's other case law that supports that. I just haven't had time to prepare things for you.
As I said, you've been given way more time than most individuals coming before this court.
Considering that I'm struggling with the probate court, so many filings, and appellate court, and my unstable living situation, I would argue that I could be given a little more time.
Anything else?
Just think that the court is letting, as with so many things that happen with probate court involvement, the lawyers have sort of gone around the rules, and it's
So now you're accusing the lawyers of going around the rules and the court's letting them.
well, by signing the order of eviction when it really.
Okay, well, let's get this clear. Sign the order of eviction, stayed it, had a hearing, gave you additional time once I found out that it really wasn't a residence and things hadn't been removed, and now we're here today. So if you want to talk procedurally, while it is unusual, if you want to talk procedurally and any detriment to you in that, it's not there.
Well, I have been harmed by the removal of my vehicles. And that was a part of the eviction proceeding. He removed the vehicles. The eviction server person required that the vehicles be towed before he would do his eviction and break into the house. And they did take things out of the house and damage some things. And I haven't analyzed what they damaged because I had been living there.
Well, before you told me they had.
What?
Before you told me they had.
I never said they hadn't damaged the house. They broke into the house and threw a bunch of things out on the lawn, and I put some things back on the porch. But
Is there anything else you want to argue to this court?
I mean, there has been harm, and the harm came after they misrepresented to the court that they were entitled, that the PR and his lawyer were entitled to have the order of eviction signed.
Sir, there's a big difference between doing something and misrepresenting something. And, I'll be honest with you, I'll listen to you but I'm not going to allow you to just come in here and just smear everybody that seems to come in your path. Because that's all that you're doing. People are going to disagree, sir. Part of the reason we're here is because people disagree. And I have to make a decision, but it has nothing to do with anybody personally. For me, it doesn't have to do with any of that.
But the actions of Attorney Magnus did have very real consequences for me over the last several months since his involvement. I mean, mainly with the Barrington Hills house and with his changing his mind about the sale of the farm and trying to get the farm sold rather than have me be able to buy it. So he has made arbitrary decisions, him and Timothy Flynn, which have
They can be as arbitrary as they want. As client, they can be as arbitrary as they want.
I would argue not. I would argue that the law.
Okay, you can argue that. I'm telling you, they can be arbitrary regarding certain things that they want to do. They don't have to operate on your moral guidelines.
Well, the law is very clear that they're supposed to be impartial and not do things that benefit the favor of one devicee over another.
Then that you need to take up with the probate court if you believe that that's happened.
I absolutely believe it's happening, and I absolutely am taking it up, and that's fine.
Okay, then that's where that argument belongs.
That's part of the reason I need more time here, because all of this helps to speed along what should have been more deliberately handled in the probate.
Anything else?
What remedy is there for the harm that's been done by Attorney Magnus having my vehicles towed and that was only because of the August 21st order that you signed when Attorney Magnus implied that he was continuing, we've discussed. What remedy is there for the harm that I suffered? And there is harm to the.
What kind of vehicles were these?
It's a 2002 Pontiac Grand Prix that was functional. It needed a new fuel line. That's
A 2002 Pontiac Grand Prix.
yeah, I mean, it's not worth much.
The other car. What's the other vehicle?
Submitted pictures of vehicles when we told them.
The other car is a 1990 Honda Civic, which is actually worth more than the Grand Prix, even though it's not functional.
Yeah, that's people judging what American cars are worth. Go ahead.
Well, it's because there's some like people, fans of a movie, people like this old model Honda hatchback, and the engine in my Honda Civic has only 100,000 miles on it, and there's other parts. So I've seen ones that are just like a shell for 1,000 or more. So my car with significant parts was worth over $1,000, the Civic. And
Okay, so it's $1,000. And then how much is the other one worth? It's a GM, so
The
it's
other
not
one-
much. I'm a Ford guy.
The other one was worth between 500 and 750, where scrap value.
So we're talking $1,500.
I would say the city is actually worth more than 1,000. I said 1,000 per.
How much are you, how much are you saying? 2,000 total. All right. Anything else?
Briefly, illustration.
You may take whatever time you want. You have been very patient and listening. Go ahead, sir.
It won't take long. You can see the same case in the exact same way. I'll just say we're the latest in a long line of judges and attorneys engaged with Mr. Samuels in the exact same way. We have, I think, 7 other eviction cases. There's 9 appeals, maybe 10, I think, court of appeals with regard to, this goes back many years. The point being, I did put the court in this position by missing that 56-day court rule.
And can I just stop you there? Because, and I think it's important to point out, as this gentleman has been sort of smearing you, one of the things, and I remarked it to my staff when I went back and back, and that is that you came in, and for somebody that's looking to hide stuff or do whatever, the shady stuff he says you're doing, you stood before this court, said, look, Judge, I wasn't aware of this. I did this. This is what I did. Just straight up. And I'm going to just tell you this, Judge, I appreciated that. That's how lawyers practice. Go ahead, sir.
Thank you. Yeah, so like I said, at the last hearing, I learned that in real time, right? So we could have had this hearing 2 weeks earlier. But as you said, the result's the same. Mr. Samuels doesn't live there. We removed his cars. Yes, they're waiting at the impound for him to pick up. No problem. And I just asked the court issue the order so we can move this whole process forward.
All right.
Yeah, they want a lot of money to pick them up. So that's, and it's, I have another property a mile away that if he worked with me, we could have put my cars at my other property a mile away. Now they're somewhere 20 miles away. And it's.
Or if they were drivable prior to this happening, you could have moved them there.
They weren't driving.
Okay, then you could have gotten a tow and got them there.
Exactly. A mile would have been an easy, cheap tow, but Attorney Mondes didn't work with, didn't contact me.
You know, I just hook into my truck and drag it. I'm kidding. Go ahead.
Well, no, I actually could have done that. To take him down.
So why is that his fault?
Because he didn't let me know that he was.
Because everything is his fault.
There was no reason for me to think that he would tow the cars in a month.
Okay.
There was no reason for him to have done that without notifying. He gave me no notification at all. And he was notifying me of other things. He refers to evictions and all. The bottom line is that when I was conservator, I did for my family what anyone would want a conservator to do. And I was only removed as conservator 2.5 years ago because other attorneys said things in court, material facts that are absolutely not true, that the judge even acknowledged when seeing video.
Oh, so these were other lawyers that lied?
No, it's again, my sister's lawyer is the main.
Oh, okay. All right. I'm just trying to get it clear.
Well, my sister's lawyer has misrepresented material facts many times.
Okay. There we go again.
She has.
Okay.
Can prove.
Okay, that's fine. Is that before me?
Attorney,
Is it before me? Is it before me?
In a way, it is.
Why is it before me?
Consequences of it are before you. All of this has happened because from the beginning, I did what anyone would want as conservator. And instead of it being applauded, I markedly increased my parents' wealth. I did everything the way Dad wanted. I cleaned up their house to such that the judge, seeing the video, said, yes, it does look good. But the attorneys for other sides said, I didn't do what I did, even though they had video, proof, and later acknowledged that I did what I said I'd done, but they hadn't believed me. So it is before you because the consequences of everything that's gone on the last 4 years lead us to where we are. So this is just the final action in a terrible sequence of events, which started with my sister betraying my parents when they were clear on what they wanted for the future. And both my parents died prematurely without me caring for them because of the probate court involved. And it's obviously sounds crazy, but it is.
No, it just sounds like another one of your attacks on somebody else. That's what it sounds like to me.
So my dad was saying he wanted me to keep caring for him, and I was having him gain weight, and they took him away from me. It's fine.
Sir, then all of that has nothing to do with this case.
Indirectly, it does, because it led us to where we are. It's like there should be, my dad's will said the PR would be my sister and me. We only have an independent PR because of actions by my sister's lawyer 2.5 years ago, but I didn't even understand.
Then you need to bring that to the probate court. I can't do anything about that. Even if, for whatever reason, I thought you were right, and I have my serious doubts as to whether or not you are. Even if I had my doubts, there's nothing I can do.
Well, you could just do nothing rather than enter the order of eviction.
You haven't been here before. It's rare I do nothing.
Well, in a case where there's some question as to,
No, I really don't have a question.
there are some appellate cases relating to the district court's involvement in estates and landlord tenant issues.
If you believe that my action is inappropriate, sir, you have all of your appellate rights.
I'm already completely overwhelmed with what I'm trying to do. And
Whether or not you choose to exercise those rights is beyond me. But you will have them.
I just,
And unless there's anything else, I'm ready to rule.
I understand that, and I just think that you're, as with everyone, respecting the lawyers instead of analyzing actions that they've done. Like,
Sir, you know what? I'm going to stand in brief recess. I will come back. I promise you I will come back, but I don't want to say anything that's going to get me in a whole bunch of trouble.
All rise.
I told you I'd come back. The fear of saying this, is there anything else from either party before I rule?
Okay.
Sir?
just please try to understand.
All right. Oh, I do understand. And I've listened to almost 45 minutes of your argument. And at each point, frankly, and just to surmise that you were always blaming somebody else for doing something to you and then attributing some evil motive to why they were doing it. And it's all because things didn't go in your direction. In this case, counsel freely admitted that there was a violation of the 56-day rule. However, this court determined that there really was no harm that inured to the defendant because of that. And the reasons for that are, number one, the defendant did not reside in the address. Number two, property was not removed prior to the defendant filing what I'll call his motion before this court so that he could be heard, with the exception of 2 vehicles. It's also come out during the course of this hearing that despite that, defendant had access to those vehicles in the sense that he could have paid for those vehicles and retrieved them, did not, and chose himself to not do that.
Because of lack of money.
Okay, I've let you talk for whatever. It is my time. Am I clear on that? And all of that having been said, while this is unorthodox, this court does believe that it preserves the protections that the 56-day rule, the 2 56-day rules actually, have in place, and the intent of those rules, so that stale orders and other things don't happen. The defendant has had an opportunity, certainly, to be heard before this court on the first occasion, back on September 3rd. The court heard the initial part of this, gave the defendant additional time, which he did not use to provide anything in writing or otherwise to the court regarding this particular proceeding. And it seems that his major beef has to do with the actions of the personal representative, counsel, the court, and everything else. And I guess prior to my going off of the bench, he, quite frankly, had not, as of yet, taken a shot at me, and it was about to. And so I certainly needed to remove myself before I responded back, and may have responded back in an inappropriate fashion. But you can take whatever shots you want at me. I'm sure in whatever other hearings, my name will come up as somebody who has done something wrong to you. I don't think that I have. So, having said all of that, it is the order of this court that the order of eviction will stand, and that the execution of the order of eviction signed by this court may continue. The defendant may seek a stay if he wishes. This order to give the defendant an opportunity to seek a stay before the Oakland County probate court, this order will take effect for the continuation of it 7 days after the signing of my order. Thank you.
Should I submit a proposed order?
I really like having you guys here, but I'm going to do an order. All right. So if you want to wait, she's beginning that and should have it for my signature shortly. Thank you.